This video is going to discuss the last two sections of your Rule 111, that is your Section 6 and Section 7. So we are done discussing Section 1, and Section 1 is about the institution of criminal, and together with that, criminal is the civil actions. That is the general rule. Dapat as early as now, pag binasa niyo yung title ng bawat section, meron na kayong more or less an idea of what it says. Para pagdating sa midterms at pagdating sa finals, lalo na sa bar examinations, hindi kayo mangangarag. So kahit ang babasahin nyo na lang is yung title or yung babasahin nyo na lang yung caudal the night before the examinations, madali na kasi meron na kayong idea of what it says. So we are done also with Section 2, when is the separate civil action suspended. Section 3 is when is the civil action, when can the civil action proceed on its own or independently. Section 4 is about the effect of the death of accused on civil actions. Regarding the death of the accused, isa lang ang tatandaan: the only time it will extinguish the civil liability or the civil aspect is during, or there was already, the death occurred after arraignment and during the pendency of the criminal action. The rest, it will not extinguish. Section 5 is what is the effect if there is a judgment already rendered in the civil aspect? Will it bar the criminal action? Answer is definitely no. Let's go back to this scenario. We have been discussing this in the past videos. We said that if the civil action was filed ahead or it was instituted ahead and your criminal action was filed later or it was filed subsequently, then what will happen? What will happen is there will be suspension. And what case will be suspended? Is it the civil case or the criminal case? Answer is, what will be suspended is, of course, the civil case. What will be suspended is the civil action. Bakit? Because if you're going to read your Section 2, very clear that Section 2 is telling us to wait. Wait on what? Wait until there is a judgment rendered in the criminal action. But take note ha, ang sinasabi niya is wait until there is a final judgment rendered in the criminal action. But is there an instance wherein it is the criminal action that is suspended? Hindi na yung civil action ang masususpend, kundi itong criminal action. Is there an instance? Answer is yes. And that is the concept of your prejudicial question. So what is this concept of prejudicial question? The answer can be found in your Section 7 of your Rule 111. So here we are going to talk about the elements of a prejudicial question. So pag pinag-uusapan yung elements or yung prejudicial question, dalawa lang ang dapat nyong tandaan. First is the issue and the second one is the decision. Kagaya lang yan ng case digest na ina-assign ng mga professors nyo. Diba, pag nag-a-assign si prof ng case digest at kayo ay pinapatayo na during recitations, ang tinatanong lang naman is, what was the issue in that case? In the case of people versus sabihin natin people versus Juan de la Cruz or people versus Vong Navarro. What was the issue and what was the ruling of the court? So it's the same when you talk about your elements of prejudicial question, because here number one element is, ang una nyong tatanungin kung meron nga bang prejudicial question is the issue in the civil action? Take note ha, the civil action was previously instituted, meaning it was previously filed or it was filed first. So, is the issue in the civil action similar or intimately related to the issue in the criminal action. The criminal action is subsequently filed, or it was filed later. So are the issues similar or intimately related? Next is the decision. So is the decision in the civil action determines whether or not the criminal action will proceed. Is the decision in the civil action will determine whether the criminal action may proceed. So these are the elements of your prejudicial question. For you to understand better the concept of prejudicial question, let us take a look at this case of Ras versus Raul. This was decided in 1980, but still a very good case. So what happened here is you have Mr. Luis. What did he do? He filed a complaint, a civil complaint against Alejandro and Bienvenido. Because according to Mr. Luis, there was double sale of the property. According to Mr. Luis, the first sale, the first bentahan happened between him and Mr. Alejandro, the first transaction. And the second sale or the second bentahan happened between Mr. Alejandro and Mr. Bienvenido. Kaya pag binasa mo yung prayer ni Mr. Luis, you will read there that Mr. Luis wants to nullify the deed of sale executed between Alejandro and Bienvenido, and that the deed of sale between him and Mr. Alejandro should be the one considered as valid. It should be the one considered as valid. Kasi nauna nga naman daw siya. But ano ang naging sagot ni Mr. Alejandro? According to Mr. Alejandro, "Hey, Mr. Luis, I never sold the property to you. Hindi ko binenta ang property sa'yo." Sagot naman ni Mr. Luis, "Anong hindi binenta? Basahin mo yung deed of sale. Nakapirma ka dyan." Ano ang naging sagot ni Mr. Alejandro? "Yeah, it's true. There is a signature there, but that signature is not my signature. That is a forged signature of mine. Therefore, the deed of sale that you are talking about is a fictitious deed of sale that is not existing at all. That is not an existing document." So what happened? What happened is Mr. Luis later on filed a case for estafa. And what is the basis of your estafa? The basis is the alleged double sale involving the same property that is the subject matter of the civil case. To determine if there is a prejudicial question, let's go back to the elements as stated in section 7. So first, what must we do? We must check first if there is a civil action that was previously instituted. In the case of Ras versus Rasul, was there a civil case filed ahead? Answer is yes, because Mr. Luis first filed a civil complaint against Alejandro and Bienvenido. Next, was there a criminal action subsequently filed or filed after the civil case? The answer is again yes, because later on, Mr. Alejandro filed an information for estafa. Let's go now to the most important thing that you have to remember, and that is the issue. Is the issue in the civil case similar to your issues in the criminal case? Is the issue in the civil case related, intimately related to your issues in the criminal case? What is the answer here in the case of Ras versus Rasul? That is yes. Because pag binasa mo yung civil case ni Mr. Luis, actually, the issue there all boils down to, was there a double sale? Nagkaroon nga ba ng dalawang beses na bentahan ng property? And what will happen if the court now declares, if the court renders a decision that there was no double sale. Mr. Alejandro is telling the truth that he never sold the property to Mr. Luis. So in that case, kung walang double sale, what will happen? What will happen is definitely Mr. Alejandro is innocent of the crime for estafa because again, your crime for estafa is based on double sale. Kaya itong resolution ng court in the civil case or the decision of the court in the civil case should be present because that is the determining factor whether or not your criminal action will proceed. Kaya tatandaan nyo palagi pagdating sa elements, not only the issue must appear but also the resolution. Take note, ang ginamit ng batas is and means both number 1 and number 2 must appear for you to declare that there is a prejudicial question. If nalilito pa rin kayo sa concept ng prejudicial question, ask yourself this one. What will happen if your criminal case for estafa is not suspended? If this is not suspended, then for sure, this criminal case will continue. Magtutuloy-tuloy ang hearing dyan. At yung civil case will be suspended. That is what Rule 111 is telling us. But if you're going to allow this criminal case to continue, of course, later on, there will be a decision rendered by the court. At yung decision na yan, dalawa lang ang pwedeng mangyari. It's either Mr. Alejandro is guilty of the crime or Mr. Alejandro is not guilty of the crime. If the court will say that Mr. Alejandro is guilty of the crime and later on, your civil case will be resumed and in your civil case, sabi naman ng civil court na ay, totoo nga yung sinasabi ni Mr. Alejandro. He never sold the property to Luis and he never signed that deed of sale. His signature, therefore, is fake or is a forgery. So, in that case, ano ang magiging scenario? You have now two conflicting decisions or two conflicting resolutions. And the resolution is one in favor of Mr. Luis, nanalo si Mr. Luis, at isang desisyon na natalo naman si Mr. Luis. So ano ang mas mangingibabaw dun sa desisyon na yon? Definitely, it is the civil case. It is the civil case because according to the Supreme Court, prejudicial question exists when the matter, in our case, the matter is about the double sale. The matter is a matter that is under the authority of the civil court. Therefore, it should not be passed to the criminal court. So, yung issue ng double sale should be decided by the civil court and this double sale should not be decided by the criminal court. So, if you are the lawyer and after determination, nakita mo nga meron lang prejudicial question, what are you going to do? The first thing that you are going to do is you should file a motion to suspend the proceedings based on prejudicial question. So, you are going to file just like this one, an urgent motion or just a motion to suspend the proceedings based on prejudicial questions. And most likely, the court will not act immediately on your motion because it will allow the other party or the opposite party to file his comment or opposition to that motion. So, this is for your legal forms. Tanong, where are you going to file your motion to suspend proceedings? Answer is, depende. Because if the case is under preliminary investigation or kung nasa korte na yan at nagkakaroon na ng hearing or kung ano ang status niyan sa court, then you have to file it in the office of the prosecutor if under PI, and in the court if nasa trial na. But take note that if you're going to file it in the court, you have to do that before the prosecution rests its case. Basis, that is your section 6 of your rule 111. So take note of this term, before the prosecution rests. So this is according to section 6 of your rule 111. So before the prosecution rests its case, make sure that you filed already your motion to suspend the proceedings based on prejudicial question. But attorney, kailan ba ito nangyayari? Kailan ba nagre-rest ang prosecution? You read your section 11, rule 119. That is the order of trial. So kung yung stage na ng kaso is nasa trial na, then who will act first? Who will act first is the prosecution. The prosecution shall present first the evidence to prove the charge and then the civil liability. But is this the case always? Answer is definitely no. Because if the accused admits that he committed the act, sabi ni accused is, oo po, judge, ako po yung pumatay dyan kay Mr. Juan de la Cruz, then in that case, the order of trial will be modified. Ito yung sinasabi nating reversed trial. So, take note of that ha, yung order of trial, nauuna ang prosecution, next is the accused. So, pag tinanong na ni judge na, fiscal, meron ka pa bang mga testigo na hindi pa na ipipresenta? Sasabihin naman ni fiscal, hindi po, tapos na po ako judge, I rest my case. Then that is what the law is telling us, that you have to file here your suspension or your motion for suspension before the prosecution rests its case. So differentiate that from your before the prosecution starts presenting its evidence. Kung dito patapos na, here magsisimula pa lang. Saan natin to nabasa? That is your section 1 of your rule 111. Before the prosecution starts presenting its evidence, you should reserve already your intention to file in a separate action the civil aspect of the criminal case. So, before the prosecution rests, you can file a suspension. Before the prosecution starts presenting its evidence, you should reserve. If there is a prejudicial question, what else can you do? You can move for the suspension of the arraignment. That is very clear according to section 11 of your rule 116. What you are going to file is a motion to suspend arraignment or motion to defer arraignment.